Welcome to the October docket for the Court of Criminal Appeals of the Eastern Section. On the panel today, we have Judge Camille McMullen from Memphis, Judge Jill Barty Ayers from Clarksville. I'm Kelly Thomas from Maryville. Our appreciation to Jim Hivner and Nick Morgan for making all this work. There's a lot that goes on to get us to where we are right now, and we appreciate everything that they've done. As usual, it's 20 minutes to the side. If the appellant wishes to save some time for rebuttal, let me know when you start your argument. I don't think they're in preliminary, so if you will call the next case, please.
Jessica R. Adkins versus State of Tennessee.
Hey, Mr. Hyder.
Good afternoon, Your Honors. Cameron Hyder on behalf of Jessica Adkins. I am here today to request 5 minutes of rebuttal time if necessary.
All right, sir.
This case is a post-conviction appeal that has arisen from a first-degree murder conviction of Ms. Adkins. Ms. Adkins and her co-defendant, Mr. Long, were convicted of first-degree murder and received sentences of life imprisonment. Ms. Adkins then filed a post-conviction petition regarding ineffective assistance of counsel with regard to counsel Jim Bowman and Donna Bolton. Upon an evidentiary hearing, the trial court found that there was no ineffective assistance of counsel, and Ms. Adkins then instructed me as her attorney to file an appeal. Today is going to be a pretty short argument on our basis with regard to the allegations that we have raised before Your Honors. The main crux of this is Ms. Adkins' alleged misunderstanding of what her abilities were and her inclusion in her defense was. We presented at the evidentiary hearing that she had requested a private investigator to be appointed. That did not happen. This was a case where it was a newborn baby that had died. There was a lot of questions with regard to medical concerns. There were a lot of questions with regard to several actions by Mr. Long, the co-defendant. Ms. Adkins had requested that private investigator be appointed or be in service to her as part of her defense team, and Mr. Bowman and Ms. Bolton failed to do so. She also had asked her counsel to sever these cases. Ms. Bolton, during the evidentiary hearing, did testify that there was a strong possibility that Ms. Adkins would be found not guilty. And we do believe that that shows that it would have behooved counsel to sever these cases. Our belief is the jury hearing Long and Adkins' case together, it proposed to them an outlet to tag, for lack of a better word, Ms. Adkins onto Mr. Long's conviction. Our concern there is that deficiency in not severing those two cases led to the prejudice of Ms. Adkins being convicted and facing now what she is serving, a lifetime of imprisonment. Outside of that, the other issues are pretty narrow and very specific with regard to the brief. Ms. Adkins had some concern about her ability to testify. The record will reflect that she did participate in a MOMON hearing. At the evidentiary hearing, Ms. Adkins testified that she did not understand the gravity of her ability to testify and what impact that would have upon the jury. Our position is that Ms. Bolton and Mr. Bowman did not adequately prepare her for that avenue of choice that lay before her. And if she had testified, and she testified at the evidentiary hearing, if she had known what type of impact it would have had, she would have chosen to testify. But most importantly, with regard to that, the state had offered a plea deal. There was some confusion based on testimony at the evidentiary hearing as to what Ms. Adkins understood the plea to be and what the plea offers were presented and how they were presented by Mr. Bowman and Ms. Bolton. Ms. Adkins testified that if she had known of the one plea deal that was offered, that she would have taken that plea deal if she fully understood the gravity of what she was facing. Ms. Adkins is a young individual. She'd never been involved in the criminal justice process before. This is obviously something that had occurred. In fact, the night before the trial, she was at the emergency room with her other child. So she was going through a lot of emotional distress between the death of her one child and the sickness of her other child. And she testified at the evidentiary hearing that this clouded her ability to understand what was happening, and that she effectuated that to counsel, and that counsel did not take the appropriate steps to ensure that she did in fact understand what was happening, nor did they take the appropriate steps to attempt to delay the process so that she would be in her right state of mind to stand trial for such a serious crime. If there are no questions of the court, we rely on our brief for the other issues, and we would end our argument at that and ask that the court affirm our petition for post-conviction where the trial court denied it. So we'd ask that you reverse the finding of the trial court. Thank you.
All right, sir. Thank you. General Redding.
May it please the court, Catherine Redding on behalf of the state. As an initial matter, the post-conviction court lacked jurisdiction to consider the untimely petition for post-conviction relief. The court should have, as the state urged below, dismissed the petition as untimely because it was filed outside of the 1-year statute of limitations. Before I get into this, I have to apologize for a typo in my brief. All of the dates we are dealing with here are in March of 2015. So the statute of limitations expired on March 4th, 2015. The petition was signed and notarized on March 3rd, but not filed until March 11th, which is outside the statute of limitations. The petitioner here made no effort to show that her petition was timely filed, although it would have been timely filed had she delivered it to the prison officials within the time fixed for filing. She did not complete the section of her pro se petition stating when she delivered the petition, when she turned it over for mailing, nor did she explain the untimeliness of her petition at the evidentiary hearings. Further,
I think it's close to the notary portion of the petition, but that's just blank. Is that what you're saying?
yes, Your Honor, there is that section that says I delivered it to the prison official on this date for filing, and it's empty. There's nothing there.
Okay.
And further, the petitioner's claims for relief do not fit within the statutory exceptions for the statute of limitation. She's not offered any facts to show that application of the statute of limitation would deny her due process. Statute of limitations is jurisdictional, and this court should find that the post-conviction court lacked jurisdiction to consider the petitioner's claims and dismiss this matter. But even if this court were to treat the petition as timely filed, the petitioner is not entitled to relief. First, the petitioner did not prove that trial counsel were ineffective for failing to hire a private investigator. And I'll note for the court's benefit that defense counsel did hire an independent legal nurse consultant to go through all of the medical records in this case. But what the petitioner has claimed on appeal is that trial counsel should have hired a private investigator to corroborate her claim that she was unaware of the victim's injuries and to serve as a conduit between herself and her attorneys. But as to this first part of the claim, the petitioner didn't show that hiring an investigator would have corroborated her claim that she didn't know about the victim's injuries. She should have called a witness at the evidentiary hearing to show what undiscovered corroborative evidence an investigator would have found that trial counsel wasn't able to find, that the independent legal nurse consultant wasn't able to find, but she did not call a witness to establish these facts for the court. Second, the petitioner failed to prove that an investigator was necessary to serve as a conduit. James Bowman testified that the petitioner had ample opportunity to suggest potential defense witnesses. Donna Bolton, her other attorney, testified that she was in constant contact with the petitioner. The petitioner was always able to reach her, and that she and Mr. Bowman met with the petitioner numerous times. As a result, the petitioner hasn't shown that counsel was deficient in this respect, nor has she shown a reasonable probability that the trial outcome would have been different to severance. So in order to obtain relief on this claim, the petitioner has to show, one, that a motion to sever would have resulted in severance, and that two, there's a reasonable probability the results of the proceeding would have been different had the defendants been severed. But the petitioner has not shown that there are grounds for severance in this case. First, she offered no proof showing that her co-defendant made a statement, out-of-court statement that referred to her but was inadmissible against her. She didn't allege, much less show, that severance was necessary to protect her right to a speedy trial. She didn't prove that severance was necessary for a fair determination of her guilt or innocence. She does suggest that the disparity in the evidence between the evidence of her criminal behavior and the evidence of defendant Long's criminal behavior, because there was a disparity, she's entitled to relief. But that kind of disparity in the evidence isn't alone enough to warrant severance. And fourth, there was sufficient evidence to support the allegation on which the petitioner was joined for trial. She's not entitled to a separate trial just because there was particularly damaging proof introduced against her co-defendant. Because it hasn't shown that a motion to sever would have been granted, she's not entitled to relief on this claim. As to the petitioner's claim regarding counsel failing to explain the severity of her charges, as an initial matter, she failed to show counsel was deficient or were deficient in this respect. Counsel testified that the petitioner was aware of the seriousness of the case, the consequences of a first-degree murder conviction, and the fact that she could face life in prison. Counsel denied telling the petitioner that the state had no case, or that at most she would be convicted of criminally negligent homicide. And the post-conviction court accredited counsel's testimony on this issue. The petitioner didn't offer any proof at the evidentiary hearing that contradicts the post-conviction court's finding. Even if counsel were deficient, the petitioner has not proved prejudice. Here, what she's claiming is that had counsel explained the true severity of my charges, I would have accepted the plea offer that was made by the state. But the petitioner has not even proved that the state actually made a plea offer that she could accept. Counsel recalled discussing a plea offer contingent upon the petitioner testifying against defendant Long, but neither of her attorneys recalled an actual firm offer that the defendant could have accepted. And even if the state did make a formal plea offer, the petitioner has failed to prove that it would not have been withdrawn. The recollection of trial counsel was that this offer that was under discussion was contingent on the petitioner testifying against defendant Long. But Donna Bolton testified that the petitioner didn't see anything. She had no testimony to offer against her co-defendant. Therefore, even if counsel were deficient or failing to explain the full severity of her charges, no prejudice could have occurred. And finally, the petitioner did not prove counsel were ineffective for failing to advise her on her right to testify and the consequences of deciding not to testify. First, petitioner hasn't shown that counsel were defective. Counsel testified that they met with petitioner extensively to discuss the possibility of testifying. Mr. Bowman specifically advised the petitioner of the advantages and disadvantages of testifying. Counsel explained what would happen or what could happen if the petitioner testified and what could happen if she did not. And Mr. Bowman's recollection was that the petitioner would not have made a particularly great witness, but it is clear that that her counsel advised her of her right to testify, that they never told her not to testify, and that there was a moment hearing at trial with the appropriate questioning, and the petitioner admitted all of those things at the hearing. Even if counsel were deficient, the petitioner hasn't shown a reasonable probability that the trial outcome would have been different but for this alleged deficiency. The petitioner, most importantly, at the evidentiary hearing, did not offer any proof establishing what she would have said had she actually taken the stand, had she decided to testify on her own behalf. And this court can't speculate on what benefit her testimony might have offered when it does not know what the petitioner would have said. And for those reasons, the petitioner is not entitled on that particular claim of ineffective assistance of counsel. If there are no questions, the state asks this court to dismiss the petition for post-conviction relief as untimely, or in the alternative, affirm the judgments. Thank you.
Thank you. Mr. Hyder?
Just very briefly with regard to the timeliness issue, of course, that issue was relevant prior to the appointment of my being her post-conviction counsel. The record, I do believe, will reflect that the post-conviction court treated the signature date of May 3rd as when it was properly effectuated, and proceeded to appoint me as counsel to file an amended post-conviction petition. Therefore, I understand the jurisdictional issues that the general is speaking of, but the post-conviction court found that it was timely filed as signed within the confines of the prison. If the court has no questions, that would be my rebuttal.
All right, sir. Thank you very much.
Thank you,
We
Your
will-
Honors.
This honorable court's now in recess until 2:30 p.m.
Thank you.